Imagine a family where generations live together, share income, property responsibilities, and identity. And now imagine one member says, I want my share. And that one statement has the power to legally transform the relationships, property rights, and even the structure of the family itself. Hello everyone. Today I will be discussing partition under Hindu law, focusing not only on the legal framework but also on the practical and social challenges that arise in reality. This topic is important because partition is not just about the law, it is about family, emotions, gender justice, and economic realities. To understand partition, we must first understand the Hindu undivided family system. A Hindu undivided family consists of persons lineally descended from a common ancestor, living together and sharing property. Within this, we have the co-partners, the members who have a birthright in ancestral property. Partition refers to the division of joint family property where each co-partner gets a definite share and the joint status is either reduced or completely dissolved. Earlier, only male members were the co-partners, but with the Hindu Succession Amendment Act of 2005, daughters were granted equal co-partnery rights by birth, and this marked a significant shift towards gender equality in property rights. Not all property in a family is subject to partition. Now let's discuss the nature and types of property. The first one, ancestral property. The property inherited up to 4 generations of male lineage is considered ancestral and that can be partitioned. And this is called as ancestral property. The second one being self-acquired property. This belongs exclusively to the individual and cannot be partitioned unless voluntarily included. The third one being joint family property. This includes ancestral property and the property that is acquired using the joint family funds. So identifying the nature of property is often considered as the first legal challenge in partition cases. Now let's discuss about the types of partition. Partition can be classified in several ways. Majorly total partition, partial partition, oral partition, and written partition. Now let's consider total partition. Here, the entire joint family property is divided and the family ceases to exist as a unit. Moving on to partial partition, where only some members separate or only certain properties are divided. However, under tax laws, partial partitions are generally not recognized today. Then comes the oral partition, where the partition can even be oral if clearly proven, and in written partition through a formal deed, often registered, which provides stronger legal proof. And this flexibility shows that Hindu law recognizes both formal and informal family arrangements. Now let's discuss about the mode of partition. Partition can take place in 2 main ways. The first one by agreement and the second one by court intervention. Through agreement, family members can mutually decide and divide the property. And when it comes to by court intervention, when disputes arise, a suit for partition is filed. And the court first determines the shares, then proceeds to actual division, which is often through a family decree. And in many cases, commissioners are appointed to physically divide the property. Now let's discuss regarding the legal essentials that is required for a valid partition. The first one being intention to separate, second one communication of that intention, and third one the actual division of the property. Interestingly, Even a clear declaration of intention can sever the joint family status. And once the partition is complete, each member becomes the absolute owner of their share and the rights and liabilities are separated. And this makes the entire partition a transformative legal event. Now let's discuss about the rights of female members. A major development in Hindu law is the recognition of women's rights. Under the Hindu Succession Act of 1956 and its 2005 amendment, daughters are equal co-partners, they can demand partition, and they have the same rights and liabilities as sons. And this position was strongly reinforced in Vinita Sharma versus Rakesh Sharma, where the Supreme Court held that the daughters have rights by birth, irrespective of whether the father was alive at the time of the amendment. And this was a landmark step which was taken towards the substantive equality. Now moving to the most important part, practical and legal issues, which is the real world challenges. The first one, family conflicts. Partition often leads to emotional strain and breakdown of relationships. The second one, delay in litigations. Partition suits can take years due to complex procedures and disputes. The third point, which is difficulty in valuation. Properties like houses or land cannot always be equally divided. The fourth point, lack of clear records. Many families lack proper documentation, leading to legal complications. The next one, gender inequality in practice. Despite legal rights, daughters may be discouraged from claiming their own share. Then comes the taxation issues. Partition affects income tax status and financial planning. Further, the fragmentation of property. Repeated partitions can lead to economically unviable infoldings and landholdings. Then comes the possession issues. Even after legal partition, physical possession may be disputed. These challenges show that partition is not just a legal process, it is social and economic phenomenon. To conclude, partition under Hindu law reflects the intersection of tradition, law, and changing social values. While the legal framework, especially after the 2005 amendment and judgments like Vinita Sharma versus Rakesh Sharma, has become more progressive, practical challenges also continue to exist. Understanding partition requires not just knowledge of law, but also sensitivity to family dynamics and social realities. And ultimately, the goal should be not just the division of property, but fairness, clarity, and harmony. Thank you.